Yes, thank you, Chair. First of all, I would like to draw your attention that, as so often, the Council is absent. I think that that is a disgrace, given that it was actually the Council who, back in 2005, put a lot of pressure on this House to rush through the legislation in a very short period of time. And we see the results now. It was bad legislation. And, I really don't want to say here, as one of those who voted against the legislation, told you so, so I will not say told you so, but maybe we should learn from this experience. It should not be for the courts to undo what we have done. We should make legally sound policies. And that is our responsibility as politicians. Not only policies that are politically expedient, but they have to be legally sound. I think, Mr. Weber, your call for a new data retention directive is slightly premature, because before turning to the national laws, I would like to point out the fact that we have been waiting for a real evaluation for years, and the Member States have to date completely failed to provide any evidence, even a scrap of evidence, that this has made our world safer, Mr. Weber. That is precisely why this massive data retention is considered to be disproportionate by the courts. Now, turning to the impacts of this, first of all, I'd like to hear the Commission assessment, and I'd also like to know if the assessment by the Commission is unanimous. The assessment of the impact on national laws. Apparently they are not invalidated automatically, although it is peculiar that if the courts say that let's say the foundations of the directive are unsound, are disproportionate, then how can the national laws transposing the directives be proportionate? And what will the Commission do? Will you start a sort of inverted infringement procedures if Member States refuse to repeal the national laws, like the Netherlands? The Netherlands, where we don't even have a constitutional court that can actually check the constitutionality of the national law. Is it imaginable that national data retention laws will simply remain in force? If data collected under those national laws are used by, for example, Europol, what does that mean? Is Europol then also violating the law? What if telecommunications companies simply refuse to continue to collect and store the data under national laws? Then I would also like to know what the Commission believes are the consequences for other programmes for mass storage of personal data, like PNR, SWIFT, Eurodac, licence plates and everything else. The European Commission is currently funding the creation of national systems for the storage of PNR in 14 Member States. Does the Commission then agree that that funding is probably illegal? And then finally, to the Commission and Mr. Weber, yes, we want to keep our people safe, Mr. Weber, but with really effective laws. We have not had any proof of the effectiveness of data retention. So will the Commission consider a wholly new approach with less intrusive and smarter means to keep our people safe?